a.m. Pacific Time, noon Mountain Time. My name is Jay DeVoy. I'm a partner in Holland & Hart's Las Vegas office focusing on healthcare and healthcare compliance. This is part of the ongoing healthcare compliance boot camp series. Kim Stanger is presenting a lot of these along with my colleagues, Corey Talbot, Christy Kimball, Blaine Bernard, and a number of others. Thanks for joining us today. This is the latest and the third of a sequence regarding fraud and abuse laws, and this has to do with responding to noncompliance and what your options are. The prior two installments that Kim offered had to deal with what the fraud and abuse laws are, what they look for, what the standards are for compliance, specifically the Anti-Kickback Statute, Stark Law, the Limiting Kickbacks and Recovery Act, and other laws such as the civil monetary penalty laws, payment rules, and other things that might come up on a state-by-state basis so that you're aware of that. Today we're going to talk a little bit more about what happens when you discover noncompliance, ways that you can discover noncompliance, the kind of shifting sands of what constitutes compliance or would not be noncompliance based on a proposed rule that would affect the 60-day overpayment repayment rule, and other things to bear in mind with respect to your options in the event of a noncompliance incident in terms of self-reporting to the government, depending on the nature of the noncompliance, the extent of it, and the monetary value that would likely be assessed on it. Some disclaimers to start. This is not legal advice. Some of you may be our clients, but this presentation of itself does not constitute legal advice. This is just provided for general informational purposes. The opinions expressed in here are mine alone. They don't necessarily reflect the opinions of Holland & Hart as an organization or any other partner or attorney within the law firm. And just for the purposes of programming, these webinar series run about every other week from March through June. This is the third installment. Like I mentioned, it's for fraud and abuse and responding to noncompliance. The next webinar will be on April 13th and have to do with telehealth, potential changes happening there. There's a proposed rule from the Drug Enforcement Agency with respect to online first-time prescribing of controlled substances. So that's something that I expect will be covered, and an area that is likely going to receive more attention given the flexibilities that were put into place during COVID that seem to be well received by consumers and don't appear to have created enough concern with the DEA that they want to completely revoke that kind of flexibility offered to practitioners who can prescribe controlled substances. So many changes happening there and other things to bear in mind as we go forward through this series, and hope to see you next time as well. Some of the resources that we have available will be these PowerPoint slides. I've also provided links to the self-disclosure protocols that we'll be discussing as well. One is for the Department of Health and Human Services Office of the Inspector General, and the other is for the Centers for Medicare and Medicaid Services. Their self-referral protocol is focused on payment issues. They differ slightly. We'll be talking about that, but these are the informational sheets that are published by CMS and the OIG regarding these two protocols, how they differ, how they can be used, relevant deadlines, and things that need to be borne in mind if you're curious about these for future informational purposes, or if they're a protocol that you're interested in using in the future. These do update periodically, so as noted, we'll be discussing that a bit. No sea changes, but some recent changes to these protocols that refine how they would be used, and I think accommodate some of the changes that happened that we all saw during the COVID-19 pandemic and the change in the compliance and the payer environment at that time. Some quick limitations here as well. As I mentioned, this isn't specific legal advice. We're mostly going to be talking about federal law. There will be some references to state laws that could apply and to be mindful of, and that might have similar remedies if they come up in the course of your business. But this is just intended to be a high-level overview of what to be mindful of at the federal level. Talking about any specific scenario doesn't necessarily apply to your scenario, so you would have to get specific advice if there's a particular arrangement or event that you are concerned about. The laws can change depending on what would apply. For example, there's a difference between what would be covered by the Anti-Kickback Statute versus ECRA and other laws along those lines, and what state you're in to determine what state laws would apply. So it's important to make that determination and not use this presentation and the information contained within it to evaluate any situation from beginning to end. There's a chat feature in the webinar. I will be taking questions within it. My plan is to answer questions at the end. If there are questions that come up that are timely in the course of the presentation, I'm happy to answer them as well. But the plan is to hold the questions for the end and then answer them all in the order I received them. And similarly, if you have any questions that you don't want to submit to the chat or that would be any easier to submit via email due to explaining them, you have the option of sending to me via email as well. So this is going to kind of pick up where the last presentation left off, going over what the important fraud and abuse laws are at the federal level. There's the anti-kickback statute, which is an intent-based statute that has potential criminal penalties. It can be prosecutable under the False Claims Act, and it can also be civilly enforced through the civil monetary penalties law using a administrative proceeding in addition to being pursued in court as a civil claim. The Eliminating Kickbacks and Recovery Act is a relatively new fraud and abuse law. It was passed in 2018 as a package of laws that was intended to combat the opioid epidemic and provide new resources to the government in combating payments that were being made for treatment and mental health treatment facilities, including those that provide drug rehab. And that is something where we're finally starting to get some precedent about that. There are two cases that are fairly popular. We don't necessarily need to talk about them today. One is the application of ECRA on a civil case that was decided in the District of Hawaii, and then a more recent decision from 2022 where the Northern District of California applied ECRA in a criminal case and evaluated a motion to dismiss the ECRA-based claims and provided some important clarification and distinction about the applicability of ECRA versus that Hawaii decision that initially provided some cover for compensation arrangements that fell into a gray area within the statute and its exceptions. The Ethics and Physician Referrals Act, commonly known as the Stark Law, which we'll be referring to it as, that is a common law and a source of regulation that we'll be talking about as well. That's a civil statute, which means it's a strict liability. Is it more likely or not that you made this referral or received this payment or submitted a claim for payment that was obtained based on an improper referral? All of those actions are prohibited. There are a myriad of exceptions and exemptions to Stark Law, some of which are contained within the statute itself and others that are contained within regulatory exceptions. Important point about Stark Law is that it is fundamentally a payment statute. If you're familiar with the United States Code and this area of it and the chapter that it falls within under Title 42, this is along with other payment statutes. So Stark operates a little bit differently. It doesn't have the clause that the anti-kickback statute does, but it also has, within the limited scope that it applies for referrals of designated health services, it provides a wide range of penalties and remedies available for the government to use in the event of improper payments that are made in violation of the Stark Law. Finally, there's the Civil Monetary Penalties Law, which is a mechanism to enforce certain federal laws. It embraces the anti-kickback statute and provides a mechanism for enforcing it, but also provides tools for imposing civil monetary penalties where there's an abusive ordering of services or tests that aren't warranted and aren't medically necessary, but are nonetheless paid for by federal healthcare programs. And then there's finally the state law analogs that we'll talk about a little bit, not in great detail, but just to be aware that they exist and can be other sources of compliance risk and liability. Now, briefly go over the penalties. Stark Law violations start at $26,000 per claim. That's in addition to the amount that was wrongfully paid needs to be recovered. Just on a per claim basis, these can quickly run to the millions of dollars in terms of damages. Then a kickback statute has damages and remedies that are up to fines of in excess of $100,000. You can go to jail for terms of more than up to 10 years. That's increased from 5 as part of that 2018 amendment to these laws that included the passage of the Eliminating Kickbacks and Recovery Act. And then finally, there's some discussion of the civil monetary penalties laws, which provide treble damages for improper payments. And that will be relevant to our conversation today when we talk about potential remedies or what kind of risk mitigation and damage mitigation can be done in the event there's incidents that should be self-reported to either the Office of the Inspector General or Centers for Medicare and Medicaid Services. Finally, an overview of the state regulations and laws that would be relevant to this discussion. Many states have analogs to the anti-kickback statute, to the Stark Law, and other laws that affect how business can be referred or obtained and governing the relationships between providers and related entities. Some of them don't have the robust exemptions or exceptions or safe harbors that we see at the federal level, so they become kind of blunt instruments. They also, in some cases, suffer from a lack of enforcement. So in certain states, you know that there would be a law on the books, but you don't know who enforces it. You're not familiar with it ever being enforced. And I could think of a few states in our footprint where we know that these laws exist around the books, but in living memory, nobody has ever seen it enforced or even heard whispers of it being enforced or threatened to be enforced. So it's something to be mindful of. They can create a tripwire where if an agency sees that there's an issue where they want to, have some leverage to potentially take action against a person's or a facility's license, they can invoke that law, but there haven't been any standalone prosecutions. And as a result of that, there's limited to no state or federal precedent in interpreting or construing that law or regulation. So these exist. They differ on a state-to-state basis. The enforcement landscape for these could be different. Sometimes it could be significantly different where some states are very active in enforcement. My understanding is California and New York are relatively aggressive with their enforcement. In other states, that enforcement activity is non-existent. So going back to the original point where every case and every circumstance is different, this is part of that, knowing what law applies and how it would be applied and who would be applying it. So the unfortunate reality of every business is that mistakes happen. It's why we have insurance. It's why we have policies and procedures, things like employee handbooks, and it's why we have training. The reality is that despite your best efforts, there will be incidents that are either caused by third parties or caused by circumstances beyond your control. Although we're not talking about HIPAA today, in the HIPAA context, sometimes it could be a malign actor who uses a spear phishing campaign or some other sophisticated mechanism to install ransomware on a computer or on the system itself, or the network or the system of computers that controls the network, that would basically freeze or delete all of the information that is required to be maintained as confidential with the integrity of it ensured to comply with HIPAA. Here, outsider threat is still a risk, but it can be mitigated by making sure that employees are aware of it. So frequent avenues for noncompliance is inadequate training or training that's incomplete or not up to date. Some of the things that we'll talk about today are areas of potential noncompliance, such as failure to keep up with changes in billing or payment statutes and new rules that pass on an annual basis, failure to keep up with things like the 60-day overpayment rule. We'll be talking about that a little bit. And sometimes a failure of training to embrace new and different areas of the law, new threats, things, for example, like new secure or ostensibly secure messaging apps. I think most people are well acquainted with text messaging at this point, and text messaging has been around for well over a decade, closer to 2 at this point, so that it's pretty well integrated into most compliance plans. What isn't contemplated, for example, is communication through secured messaging apps such as Telegram, or less secured messaging apps like WhatsApp. So those exist. They're outside the normal scope of texting. It varies from organization to organization as to how they're addressed. Larger organizations with a robust IT department tend to have an advantage at seeing these emerging technologies, being aware of them, and being able to anticipate what the issues are, even if it's just as simple as prohibiting their use. But they do have that advantage in having a wider scope of vision to prohibit those kind of activities, whereas some other organizations, due to generational differences or just having a leaner team that's focused on operations, isn't necessarily aware of and isn't focused on these issues the way that an organization with more resources can be. That's just kind of the reality of it. It's not an issue where there's fault or blame to be attributed, but it explains some of the disparity that you see between organizations on how they respond to emerging technologies. Another source of noncompliance could be employee error and attention or overwhelm. This is a case where employees just have to focus on patients, they have to focus on patient care and administrative tasks necessary for that. And as a result, the kind of compliance activities, the vigilance that you'd like to see or expect to see doesn't occur. Oversight can occur as well, similar to the inadequacy of training. Sometimes people don't know that there's a problem. So that's why comprehensive training is so important, to make sure that people are aware of this. ECRA, despite being a criminal statute and being very significant, is relatively new and is not as top of mind as the anti-kickback statute or Stark would be, despite the fact that it applies to any payer, not just federal payers. And while it has a fairly limited scope in applying to laboratories and mental health and rehabilitation centers, that's still a very big piece of the medical economy and can be an avenue for a lot of issues, especially with medical laboratories that seem to have interactions with most, if not all, practices for certain diagnostic tests. So that's important in just making sure that people are aware of that and the fact that some of these laws don't align perfectly. Generally, not always, but generally, compliance with Stark and compliance with the anti-kickback statute will go hand in hand. But with some of these other laws, like state laws or with ECRA, there might be gaps there that open you up to liability, even though you're substantially or materially complying with other areas of the law and satisfying the requirements, like fulfilling the safe harbors or fitting within an exception to Stark law, but still running into issues as soon as you get out of those lanes and start getting into ECRA or state law. Finally, employee conduct can be an issue. We'll talk about examples shortly, but sometimes vendors make payments to employees who don't know. That's why it's so important to train frontline employees that maybe don't come to the top of mind as needing training the way that you would think that a physician does because of their continuing medical education requirements, or the way that a revenue cycle management or billing team would need to be trained on changes in law and coding and bundling of care and treatment of payments that are made under programs such as Medicare Part D or Medicare Advantage. But frontline employees are just as important, if not more so, because they are the ones that are susceptible to these risks. I know with the HIPAA piece, we talk about how your frontline employees are some of the most important because they're the ones that are having the most day-to-day contact with protected health information and need to be reminded over and over again about the fact that they are the ones that potentially are put at the most risk and the people who are going to be the ones that can stop these kind of breaches in the first place. And at the same time, from a compliance standpoint, they're the employees that need to be told, you cannot accept gifts, you cannot accept payments. These people that come in as vendors or seeking to grow other emerging practices or to market specific services, they may be wonderful people. You might know them outside of the office, but in that moment, they are not necessarily your friends. And if they come bearing gifts, it's a moment of extreme caution. It's something that needs to be reported up within the organization. So going into greater detail with those examples of noncompliance that can emerge, any one instance is something that could be corrected and likely wouldn't rise to the point that needs to be reported to the government or would be at risk of enforcement action by the government. But if these kind of issues happen systemically, if they're pervasive, it can represent a potential loss of hundreds of thousands or even millions of dollars. One example is an employee that fails to disclose or is not asked about a family member with a referral relationship for designated health services under Stark law. So an example there would be if you're sending business to or getting business from, for example, a physical therapy practice, and the owner of that practice is the father of somebody else who's an employee or has some other less defined relationship with the company or is a contractor that has an agreement that either isn't written or might not fall within the exact parameters of the safe harbor or the Stark law exception for that, that could potentially be a problem, especially for designated health services like physical therapy. Certain things that employees can do if they're paying gratuities for business, for example, people who work in marketing, although they're not always paid based directly on how many how many patients they generate or the business or referrals that they obtain, that is a metric of their success. And one way that they can sometimes launder the marketing budget that they might be given by an organization is to convert it into things that can't be easily traced. So, for example, meals, if they're reimbursable and there aren't receipts to figure out what's happening there, it might be a way to funnel money out to people for purposes that are not legitimate business expenses. A classic example that has been popping up more and more in scams, and some of you might be familiar with because either you or your employees have received emails from people that have carefully spoofed email addresses, appear to be people you know, or very similar to people you know, and say, you need to go to Walmart, you need to be getting me gift cards for XYZ purpose. That is something where the gift cards are a great way to potentially launder money and hide what's being done, because it doesn't necessarily show up on an item, on a receipt. The person could go to a grocery store and say, oh, I spent money on this at the grocery store. It's not going to show up necessarily on the credit card statement as you purchased a gift card, and then all of a sudden in denominations of either as low as $25 or as much as hundreds of dollars, that money is flowing out and potentially being used to influence referrals, and that's something that's ultimately taxed the organization itself. Similarly, the employee can discreetly relieve cash payments, can receive gift cards, other gratuities like that, expensive dinners. So some level of monitoring is helpful to look for that non-compliance so that you're aware of it. You can route it out. You can discourage it because employees know that they're subject to some level of scrutiny. But it's also helpful to discover this. So if there's a problem, you discover it early. You can rectify it. It doesn't necessarily eliminate the damage that would have accrued from the actions that happened before, but at minimum, it can be cut off, and it would cut off the damage that occurs prospectively. And to that point, some options for discovering noncompliance. These are dependent on organizational allowances, the states where you operate, the relevant laws. These should be considered carefully before being implemented because some of them implicate federal employment law as well as state employment laws, and these might not be available in all jurisdictions, but these are items to consider for looking into noncompliance and looking for where it might exist. So if possible, just if you're a facility, if you're a surgery center, if you're a hospital and you're credentialing people who have privileges to be there anyway or privilege to admit patients, it's helpful to verify the credentials for any employee or any vendor that you would use or a contractor. That can be as simple as calling an institution where they claim to have credentials or a degree and confirming that they actually receive that, or just following up on the organizations, for example, in LinkedIn that they claim to be a member of, and just confirming that they're actually a member. It's surprising how often that will happen, and it happens with my colleagues who are frequently in litigation, where an expert will say they're a member of some organization and they're not, and it requires just a few minutes with a phone call to confirm that. So that's basically due diligence that can be done. Now, it might not be practical to do it for every single employee, but for some of them, and especially for key employees, it can be important to do that. Also, opportunities to look into this would be, where permitted, conducting a criminal background check or even a credit check. There's more requirements that go into that. It's not as simple as just demanding the employee provide it. It's important to measure twice and consult with your HR team or your employment counsel before doing so. But it can be helpful to look for big swings in credit if somebody's got a lot of debt that's uncharacteristic, if they've recently gone into a lot of debt, or if they're in a situation where they could be deemed to be at risk when they have access to things like your referral relationships, when they have access to the opportunity to make money off of potential referrals. They're in a position to influence those referrals for money that isn't going to be reported as wages or falling within a specific safe harbor. Other information that can be lawfully received, such as if an employee requests confirmation of certain information when they're refinancing a house. Why are they refinancing the house? And interest rates aren't going lower anymore, so it's an uncommon situation. I mean, sometimes it's nothing. Maybe there's a change in familial events or a family illness or some other kind of change of circumstances, but sometimes that can be useful to reveal a financial circumstance that requires closer attention and represents a potential risk vector to the company. Other things you could look for are legal processes that are received, such as summonses for lawsuits, writs of garnishment, demands, subpoenas, things that indicate the person's having some kind of legal trouble and might be also having financial trouble that could potentially lead to harm or risk of harm to the company. One good strategy that is sometimes difficult to implement in healthcare, especially in smaller organizations, but is a holdover from banking that always made a lot of sense, is the idea of making people take vacations for several days at a time. The people I know who work with banks or work for banks are required to go out on vacations of about a week at a time. There's some useful reasons why the bank would like to do that as well, to make sure the person enjoys their salary and doesn't save all of it and gets habituated to the lifestyle that the bank demands of them. But at the same time, it's very useful and it serves a purpose of making sure that things operate consistently when that person is gone. The red flag to the bank is if things change, certain transactions completely stop, certain transactions, financial characteristics change. Now, the numbers are completely different if someone's going to leave. The organization should be robust enough that it still functions roughly the same for a brief leave of absence like a week. I mean, after 3 months, that would likely be different, but having people go on vacation for 1 week at a time, 2 weeks at a time if you can do it, but ideally 1 to 2 weeks a year in that fashion, not just a string of 3 or 4 day weekends, it's helpful because if there are events of noncompliance, if there are suspicious transactions occurring, they will appear within that time frame. So that's one thing to look for as well. And also just doing standard audit procedures, understanding to the extent possible why the business works the way it does, how permissions are flowing, how money is flowing, just understanding the operations and the flow of information, such as billing, claims, funds, how funds are coming in, how funds are being dispersed, and looking for any transactions that aren't explained, looking for any lack of internal controls where it's not a question of what we do to pay invoices. If the money is just flowing without documentation, without controls, without processes, that is something worth investigating because that could represent a potential risk where money is flowing out or coming in ways that would violate applicable federal law. For other organizations where there's a lot of data to contend with, there are organizations that provide these services. They can perform a utilization review, they can review claims, and then other internal review organizations that can perform this kind of healthcare-specific audit of processes and data to make sure that this is working the way that it should. So compliance, as we know, is something of a moving target. As they say, the final rule is only final until the new one comes out. So the standards are frequently changing. Especially during COVID, at the beginning of it, the standards for compliance were relaxed in certain areas, and then beginning in, I believe it was 21, some of those flexibilities, especially for facilities such as skilled nursing facilities, started to fall off, and it's been a bit of a process to figure out what the new guidance is going to be, how that's going to look, and now preparing for, in May, the end of the public health emergency. So especially now, this is a changing target, and things are not all things, but many things and many of the flexibilities that were enjoyed during COVID are going away. Some of them likely will be retained in some way, shape, or form. For example, telemedicine has been incorporated into the future budgets through, I believe, 2024. So that will likely not go anywhere for the foreseeable future. But there are other flexibilities that might change with time and change what it means to be compliant. And literally, something you did 90 days ago will not be compliant in the future. So what you can do is follow the kind of client alerts that we publish, follow other trade organizations like the American Health Law Association, the Healthcare Compliance Association for these potential changes. At the state level, it can be a little bit different. Here in Nevada, for example, our legislature meets once every other year for a period of 120 days. Although there are public law requirements and there's public disclosures of proposed bills and legislation as it's introduced, the process through which it's heard and it's negotiated and amendments are done is, while public, and you can find it on the internet, maybe not as transparent and perhaps in terms of the political dealings, more Byzantine than we would like. So as a result, it's hard to figure out what's going to happen until it gets to a stasis point where people stop touching it for a few days and someone's paying attention to it, or until the law is actually enacted, and then the regulation and rulemaking process begins. At the federal level, it's a little bit more transparent. Healthcare is a big enough economic engine that people are paying attention to it. These trade organizations are paying attention to it, and there's generally some advance notice of what the proposed rule is going to be before it becomes a final rule. One that we'll talk about in a minute is a proposed rule that would change the 60-day overpayment rule that requires, once you identify an overpayment, that it be returned to the government, which sounds simple enough, but the standard for identifying an overpayment is not a very transparent one, and there's proposed rulemaking that would change that in a way that is more favorable to providers and impose a higher standard for what knowledge is required to identify that overpayment. So this is an important item to follow, but what I would caution is that sometimes the final rulemaking looks very different than the proposed rulemaking. Often the proposed rulemaking will draw sharp reactions from larger organizations, sometimes hospitals, sometimes payer organizations, and those entities will look to the proposed rules and make comments and participate in the federal notice and comment period. And anyone can participate in the comment process, but normally it's the larger players that have a government relations team, for which this is a well-worn path, tend to participate in that. And my recommendation is that anyone that has an interest in doing so, do so in order to make sure that their comments are heard and reflected in the federal record, because failing to acknowledge or address those comments or any part of them can be a basis for staying or halting through a court the implementation of a problematic rule or otherwise taking action that could be used to invalidate that rule in the future. And in the wake of the ACA, there was a lot of litigation over some of the rulemaking that came out of the Department of Health and Human Services. It never really went away, but it's not as prominent now as it was when the sea change of the ACA came in. So much of it was implemented through rulemaking. So the example that I provided before was a proposed change to the CMS's 60-day overpayment rule. I mean, the statute for the overpayment rule, which is at 42 U.S.C. 1320A-7K, sub D, sub 2, is pretty straightforward. When you identify an overpayment, you have 60 days to repay it to CMS. So the lawyers come and say, well, what is identification? When is it identified? And CMS responded to this by passing a regulation in 2014 that I have the citation for below, and it's a rule that says that An overpayment identified when the person has, or should have, through exercising reasonable diligence, determined that you've received an overpayment and how much that overpayment was. This goes on to say, what do you mean when you should have exercised reasonable diligence? Well, that means if you received an overpayment and you quantified it, and if you did not exercise reasonable diligence, if you did not exercise reasonable diligence and you received an overpayment, then you were determined that you should have received it. I mean, you should have identified the overpayment, returned it. So it's kind of a confusing definition because it looks at even if you didn't exercise diligence to look for this, you're still responsible if you received the overpayment because you should have. So if you would have identified it had you used diligence, then you should have identified it. It's a recursive definition. It's complicated. People have looked at it many times, and over the nearly past decade that it's been in effect, it's been a bit of a liability trap for individual practices and facilities that have to bill Medicare and Medicaid. So as noted, this creates more confusion about what is identification and what is knowing. So the proposed rule, which hasn't yet been finalized and was implemented in late 2022 and was recently discussed by a number of authorities, including the American Health Law Association, this new standard is going to, if adopted, replace this test for identification based on diligence and just look to the standard of knowledge that is well-worn and articulated in the False Claims Act, over which there is some precedent in most jurisdictions. So without getting to the bottom of what knowledge is for the purpose of this conversation, because it's not yet a final rule, there are some changes made that would define compliance differently. What starts the clock running on a 60-day rule is no longer based on what you should have done or what reasonable diligence was required, but is now based on actual specific knowledge as defined within the False Claims Act. And that is something that after investigation, you can determine what that standard is, and you have some guidance now as to how courts would interpret that if there was a need to evaluate it within your jurisdiction. Another avenue for dealing with noncompliance, if you discover it, such as overpayments. In the case of the Stark Law, any payments that were received that you shouldn't have and that were kept for a period of up to 60 days, those can be addressed through self-disclosure to the Office of the Inspector General or to CMS in the case of Stark Law. These programs have been around for 15 to 20 years. There's periodic updates to them. For the most part, they are not completely derived from, but they do have some conscious parallelism with the DOJ self-report protocols for a very expensive area of compliance, which is the Foreign Corrupt Practices Act. I've included some resources so that you can see the difference that it makes to self-report versus what damages are for making improper payments under the Foreign Corrupt Practices Act. The Foreign Corrupt Practices Act is enforced by the DOJ. It has to do with payments made to other countries in jurisdictions that don't have government integrity laws or standards and mores as developed as in the United States or in parts of Europe and Asia. What will end up happening is that there are certain payments that in America we would characterize as bribes, but in other jurisdictions are just a routine payment that is expected, like a gratuity to an official to look at your document, that without paying for it, no documents are going to look at. So the standard for what constitutes an improper payment to a foreign official is a little bit different through the eyes of the Foreign Corrupt Practices Act. There's significant potential liability under the FCPA, but that has been a reliable model for looking at the self-reports to OIG and to CMS to see that, in fact, self-reporting can cut off your liability. It can reduce the amount that you're going to have to pay, and there's a real cost savings for doing so if there's a risk of liability. But it's not all roses. You're still telling the government that you have done something that could be a basis for liability and inviting the government to come and look at your books and records, and you can't control what they're necessarily going to see. So it's a question of risk versus reward. There are resources available online and disclosed by the government in terms of how they have settled and resolved other prior cases. But those are the cases that they've settled and resolved. If you can't come to an acceptable settlement with the government, you've now given the information they need to pursue with the case, and taken away any leverage that you've had to settle this favorably. So it's not a moment without its risks, but sometimes it could be done to, for example, bring attention to something on a civil basis that could potentially have criminal liability. And even though it's more expensive, there's not the risk of being arrested or indicted, and there's a possibility of avoiding outcomes such as exclusion from the Medicare program. So as noted, there are two slightly different paths for self-disclosure. The first that we're going to talk about is self-disclosure through the OIG. This is for violations of the anti-kickback statute and civil monetary penalties law. The reason why these two go together is because a violation of the anti-kickback statute is in itself a violation of the civil monetary penalties law. So a self-report here isn't necessarily a guarantee, absent a settlement, of there not being any liability under the False Claims Act or even criminal liability for violations of the anti-kickback statute, but it can be a way to preempt that, and if a settlement is obtained and there's full disclosure made, avoiding or mitigating any harms that could occur in that under those authorities, whether criminal enforcement or enforcement of the False Claims Act. Now, the OIG scope is a little bit different from that of CMS. Like I noted, the OIG looks to violations in a kickback statute or civil monetary penalties law. Like, for example, something that wouldn't fit within the anti-kickback statute but would be something that could be punishable under the civil monetary penalties law is if there was a spate of procedures that were done that weren't medically necessary. It happens a lot with things like imaging or certain testing where it's not as invasive. There would be serious problems if there were invasive procedures performed on a patient without medical necessity that likely would involve local law enforcement and civil actions as well. But for things like imaging, it's relatively little impact upon the patient, so it's a target for these kinds of activities, and something where there could be a lot of it overprescribed that either isn't medically necessary, but it isn't medically necessary, but it occurred. It was just an edge case, but it's over-recommended for the sake of seeing what can be reimbursed by the government. So, for example, if all of the claims come back as being denied, or there's a review of this by the OIG and all the claims end up being denied for lack of medical necessity, if the OIG doesn't already have the investigation in place, that might be a moment to self-report to the OIG and try to limit the damages for doing so. There's a 6-year look back for doing a self-report on that basis, so it can be useful to take advantage of that opportunity to try to limit your liability. The civil monetary penalties, as we discussed earlier, can be as much as 3 times the amount of actual damage. If there's a self-report being made, as discussed in the OIG's own documentation, the starting point for that multiplier is about 1.5. And then, in my experience, the negotiation phase of dealing with the OIG is less than the 3 times. It depends on the kind of conduct that they occur, but they do have the ability to ratchet up what the damages are going to be. Excuse me. So that what will happen is, to incentivize the self-report, if you self-report the incident that happens, the amount of damages and the multiplier for the damages that the OIG will seek is going to be less than that the OIG will seek if they can resolve the matter with negotiation and a resolution short of an administrative proceeding. And then if the OIG is forced to pursue an administrative proceeding, then they will seek their full 3 times measure of damage for the civil monetary penalties. So they do have some carrots for pursuing the self-disclosure procedure. We'll discuss some of the benefits. You avoid key TAM actions or actions by relators, and then the penalties can be reduced, and also criminal liability can be avoided. And as discussed, the self-disclosure could trigger an investigation based on what OIG sees. They might see it as being a bigger risk than you perceived it to be when you disclosed it, and it would require complete cooperation with the government investigation, which would involve preservation and turnover of documents, presenting witnesses to be interviewed or potentially deposed, and then potential investigation of other vendors or suppliers, such as entities that you entered into contracts with to provide any of the goods or services that were the subject of the self-report, and then other sources of confirmation, such as getting information from banks and financial institutions or other payers to confirm the government's findings and the information that was provided in the investigation. So it can get very invasive, and it's something to be prepared for. CMS self-disclosure is a little bit different. It has to do with disclosures that are made based on overpayments and violations of Stark law. For that reason, there's a 60-day timeline in order to do that. There is still a 6-year look-back period for these issues, but sometimes you don't know that there's an overpayment until much later, especially if that rule changes and there is a a more favorable standard for identifying when an overpayment occurs. The risks and benefits are comparable to the OIG. However, the sanctioning authority of CMS is not quite as severe as the civil monetary penalties law, so the process isn't quite as onerous. There's also a little bit more transparency and summarization of the outcomes by CMS for its self-disclosure protocol. Where OIG does report this information, it's very much on a case-by-case basis, and you'll be aggregating data from many paragraphs that are reported by the OIG to describe the kind of settlements that it's reached. Whereas what CMS does for these cases will aggregate and summarize and table format the settlements that it's reached. Unfortunately, the last year for which data is available is 2020, but that still is a useful guide mark to figure out which cases would qualify for self-reporting. So as we see here, we have this table. It's derived from information that's available on CMS's website, and you see the amount of disclosures that are settled and the range of settlements that are resolved in the course of each year for the last 5 years, from 2016 through 2020. I should say the last 5 years for which data is available. But you can see there's kind of a breakpoint where the amount of settlements and the range of the settlements can be pretty significant. For some of these that go down to tens of dollars, less than $100, it might be difficult to justify a self-report there. That might be organizations that have, for example, integrity agreements in place with OIG to make sure that they're reporting anything that's a problem and not having it be discovered by the regulators after the fact. Just from a practical standpoint, it would not be cost effective to get a law firm involved with self-reporting this, or even having staff time go to self-reports on an individual basis that would be in the tens or even hundreds of dollars. Realistically, when you start getting into thousands or tens of thousands, then it's time to take a hard look at this, depending on how pervasive the problem is, your other facts and circumstances. Is this the first time this conduct has happened? Has there been a prior investigation? Is this something where there was a prior threat of a a corporate integrity agreement or a system integrity agreement, and something that would need to be evaluated based on the degree of prior interaction with the CMS or the OIG. So that's a consideration to make as well. So self-disclosure, as we discussed earlier, is potentially going to trigger any kind of government investigation. You have to be prepared for that, and the fact is that when making a self-report, it would be best, if possible, to treat it as a moment of getting prepared for litigation. That would involve document holds, making sure that records aren't inadvertently lost or deleted, and making sure you identify your key witnesses, and kind of doing a search to understand everything that needs to be preserved, and similarly understanding everything that will likely come to light, including emails, text messages, internal memoranda, employee evaluations and reviews, and things of that nature that would come up and likely be obtained by or disclosed to the government in the course of this evaluation. As discussed earlier, there would be subpoenas to third parties to confirm the information that's disclosed, and key personnel would likely have to be interviewed as well by the government. And additionally, there would be fairly detailed financial disclosures that would be required as part of seeking any kind of resolution for less than the full civil monetary penalty that the government would demand, or the repayment that CMS would demand in the event of an overpayment retention. And next, we talk about some general pointers about complying with government investigation, because that is effectively what you are signing up for by doing a self-report to either OIG or to CMS. These are some pointers that we have for all moments of government investigation, from responding to licensure complaints all the way up to dealing with these agencies or dealing with the DOJ in comparable circumstances. The best strategy we have discovered from our litigators who work for the DOJ is one of aggressive compliance. Demonstrate to the government that you understand the severity of the situation, over-comply, provide everything they want, almost like having a fire hose of information to the government, well-organized, manicured, fully disclosed, let the government do its work, and if it proceeds to an adversary proceeding, be prepared, and then that information will be helpful for your own experts and your own analyses to dispute what the government sets forth as its facts. But being able to have that in the first place demonstrates that there's nothing to be hidden, and it would avoid any kind of concerns on the part of the government that noncompliance is based on attempting to hide information or conceal facts or circumstances from the government. Most importantly, never retaliate against whistleblowers. They have a range of state and federal protections, especially if they are the ones that reported this information to the government, and assume anything in writing whether you think it's deleted or it's been lost already, is or can be recovered or discoverable in some circumstance. The worst case scenario is if something like this spirals out. For example, if negotiations fail, there's a settlement that's offered but not accepted. That is something that could result in a more aggressive investigation, and it could escalate to other components of law enforcement. And then what will happen in those moments are the kind of nightmare scenarios that you occasionally see on television or hear about, where agents of the Federal Bureau of Investigation come to the office, they either seize computers or they come and they image the computers completely, so they have a complete image of the hard drive. They can recover anything that's been deleted from view but not permanently deleted and wiped from the hard drive, and all of that other information can potentially be recovered and used by those agencies. So in the course of this, the best case scenario or the more realistic case scenario, depending on the facts and circumstances of a specific disclosure, would ideally be to settle with the government, get finality, know what the exposure and liability is going to be, and move on with the business and allow it to continue to exist without exclusion, without a lot of public fanfare. There might be some announcement that's made, especially if it's done through the OIG versus CMS, where the CMS data tends to be aggregated rather than reported on a case-by-case basis, where the practice and the circumstances and the amount paid is very publicly identified. But some of the other issues that can come up that I mentioned earlier would be integrity agreements, whether it's a system integrity agreement or a corporate integrity agreement that's entered in with these agencies. And sometimes there's a requirement for a third-party quality assurance expert to come in, be paid for by the entity that's subject to the CIA, and then that quality inspector will review the contracts, will review operations, make reports to CMS, make recommendations to the organization, possibly require termination or reformation or amendment of those contracts to bring them into compliance with applicable law. And that can last for a period of years. And falling out of the CIA, failing to satisfying it, breaching it, will effectively unpause any kind of administrative or civil action that the government wishes to institute in order to rectify any kind of overpayment issues for CMS, or in the case of OIG, potentially lead to a full prosecution for civil penalties. So there's a range of options there. I mean, there's always the choice too of saying no and declining the settlement, but in that case, after making a self-disclosure, it's basically giving all this information to the government that the government would need or want to conduct its own administrative action and seek greater damages than would otherwise be on offer from a self-disclosure and the settlement offer that was being extended at that time. So it's a difficult situation to be in. Self-reporting is a very serious issue where it can, within a relatively short period of time, bring finality to the issue, but it is also something that can be very expensive and have unforeseen consequences. So it's something to be very carefully considered. All members of leadership should be involved in doing this, making that determination, and understand fully the consequences that making a self-report doesn't guarantee that there's not a large civil penalty paid, or doesn't guarantee that there's no criminal prosecution, but it can get ahead of the issue, allow you to shape the narrative, allow you to anticipate the things that the government would want if it were to investigate you, and see if there's a more favorable potential outcome short of being prosecuted or, worse, being indicted. So how can this all be avoided? After talking about all the potential worst-case scenarios and the potential money that can be spent on these kind of issues, the best offense is going to be the best defense is a good offense, making sure that everybody is trained adequately, that everybody's aware of what their obligations are, and that everyone is proactively reviewing the policies and procedures for compliance, that they're in writing, and that they're periodically reviewed, if not updated. Sometimes updates might not be necessary, but on at least an annual basis, if not after specific events, it's important to go back, look at these policies and procedures, incorporate the learnings of the prior year, and make sure that they're memorialized in writing. I mean, sometimes when you look at an organization's policies and procedures, there will be something very specific that you would never think that would happen to your organization, but it's in there because it happened to them, and they just show that they addressed it to make sure it can never happen the same way again. Now, there's some critique of that, and it happens a lot in the lawmaking sphere where there's laws passed about these specific controversial or gruesome incidents, and they're very backward-looking to prevent it from happening again. It doesn't help prospectively, and that's a fair enough criticism. However, showing that you've inoculated the organization or taken steps to avoid the same loss happening again is important to do, and it shows that there's not a blindness to this and the compliance is being taken seriously to mitigate future damages. Doesn't undo what's been done, but can help undo future damages. Ideally, everyone can pay for consultants or devote the time and attention necessary to think through all of the compliance issues that could arise in the future and prevent against them, but that's not always foreseeable. Frankly, the people who want to cause this kind of harm, who want to break the law, who want to enrich themselves while endangering your organization and in violation of your rights are going to be more motivated to find creative ways to do that. So you can't contemplate everything, but the things that you've addressed should be memorialized and should show up in some way in your policies and procedures, even if it is backward looking. So we have specific recommendations here as well for training pieces for key employees. If your billing is done in-house, at least annual training about the payment rules. Normally these rules, depending on the kind of billing that they're doing, whether it's for a facility versus individual physician practices, perhaps both, depending on the nature of the company, for example, a skilled nursing facility or some other rehabilitation facility, that can be helpful to make sure that they're aware of any changes. Sometimes those are made for the facility rules, those tend to come out earlier in the fall, and then by the end of the year, the physician fee schedule is finalized. So scheduling that for the final quarter of the year could be helpful in making sure that the billing personnel is doing its job and making sure that things are properly coded, so there isn't an allegation of there being a false claim submitted that was miscoded or coded more aggressively relative to the services that were provided. And similarly, employees involved with revenue cycle management should be aware of any kind of changes that are occurring, such as with the overpayment rule or any other kind of rules that change about payments that are being made, especially if there's any kind of capitated payment or managed care payments, such as the Medicaid managed care organizations that might be operating in your state, or with programs like Medicare Advantage, because there are changes in the payment rules that periodically come out of those programs. Finally, we talk a little bit about what a good organizational response to compliance looks like. Ideally, there is one person, and they would have other resources, namely a chief compliance officer and a committee that would help them and review these, so it's not all falling completely on one person. And so they get an opportunity to measure twice with their ideas. As mentioned before, we recommend written and regularly updated or reviewed policies and procedures. Open lines of communication and lines of reporting are important as well. This is a situation where sometimes the organization chart needs to be reviewed if your group or organization has one, and it's very helpful to avoid actual or perceived conflicts of interest. The compliance officer, whoever it is, whether it's a C-level title or it's somebody else within the organization, and the compliance officer, for example, could also be the privacy officer under HIPAA and wear those hats as well, who that person reports to is going to be very important. Ideally, they would have a direct line of report all the way to the top of the organization so they could get the buy-in that they need for compliance activities. Another alternative would be the chief compliance officer or the person, the chief operations officer or the person that's responsible for the day-to-day operations of the company. What is sometimes perceived as a conflict of interest is if the compliance officer reports to the chief financial officer, because those two I don't want to say that they are necessarily adverse to one another, but sometimes the goals of the financial officer are at cross purposes with the goals of the compliance officer, where compliance might mean foregoing certain things that are financially advantageous to the company. So putting those as direct reports putting the compliance officer as a direct report to the financial officer, even if there's great institutional alignment on those points, it can be perceived as a conflict of interest and is not a recommended configuration. As discussed earlier, we recommend training, education, auditing, and monitoring of employees through all legal means that are possible. And it's kind of steering the organizational culture so that there's opportunities for auditing, that there's transparency, so that there are policies and processes in place, not for the sake of just having process, but to make sure things are working correctly and that the necessary permissions are being satisfied and that there are checks on how the monies of the organization are flowing in and out of it, and to monitor it. Encourage people to take employees. Hopefully, everybody in the organization is well compensated and financially secure and can take a week off without thinking about it. You can bid them and do it with their family, and while they're gone, make sure that things work the way that they do, even considering that there would have to be 1 to 3 other people covering their various job functions. And
the indicia that the compliance program is working is that the only problem that's caused is a little bit of extra workload for other people within that week, but the wheels keep turning and things don't fall apart because that person is gone. That is a problem if they do, and it is a problem that can be indicative of compliance risk. Finally, responding to non-compliance with corrective actions, fix the problem. Don't put it on the rug. It can be something that requires self-report, but whatever is done, stopping the bleeding is the most important piece. Won't cut off your potential past damages. It might be something you have to self-report. It might be something the government contacts you about. But stopping the non-compliant activity is going to be the most important, whatever form that takes. And if necessary, making it clear in your policies and procedures, your handbooks, your training, your onboarding, and any kind of employment contracts that discipline for violating these laws and subjecting the company and all of the other employees to such risk, including risk of the entire organization, can be met with discipline up to termination. The Office of the Inspector General has some good resources for this and can give input or not particularized input or specific to your organization, but ideas about what it would look like in terms of having a written compliance program, and that link is available in this slide. So, as mentioned before, the next installment in this webinar series is going to be on April 13th, 2023, same time, same place, and the topic will be telehealth and the topics that I mentioned earlier. Are there any questions at this time? If anybody would like to chat them or if anyone would like to email them to me, we have a little bit of time left, and I wanted to make sure we had some incorporated to answer any questions that were needed at that time. All right, well, hearing no questions, I appreciate everyone's attention today. Thank you very much. If you do have any questions, my information is here. The slides will be up shortly. There will also be a recording of this webinar made available at some point in the future. If anybody needs anything, please let me know. I will look forward to hearing from you via email or reading any chats that you have. Still, I have not seen any chats from the group yet. So if anybody has any questions, we appreciate it. We look forward to working with all of you and answering your questions. And I will be speaking to you again at future webinars over the course of these, over the course of this series that we put together, and we look forward to bringing to you.